Welcome to our program on confidentiality of disability accommodations and the Vesco process under the Vesco case. My name is Judge Steve Austin of the Contra Costa Superior Court, and I'm joined by Georgia Koo, Court Manager of the Santa Clara Superior Court, and she's their ADA coordinator there as well. Let's talk about the confidentiality provision of California Rule of Court, Rule 1.100, Subdivision 4. The court must keep confidential all aspects of the accommodation process. That's a kind of a difficult concept, I think, for a lot of people to get their hands around. And that's because we, judges, don't like confidential matters where one side doesn't get to know what the other side's doing in a case.
That's right.
That's ex parte, and it really scares us. And we don't want to be involved in that process, and most court staff, they have a fear of it as well. Because generally, that you can't do that. ADA accommodation process and accommodations under the rule of court are different. And those require confidentiality. Even if one side's a litigant, the other side doesn't get to know about that in almost all circumstances. Under the rule, the court must keep confidential all information of the applicant regarding the request for accommodations. Can't be disclosed to the public or even to the other side. Can't be disclosed to persons other than those involved in the accommodation process, even for those working in the court system.
Yes, Judge, that is correct. That includes applicant's identity, all oral or written communications from the applicant, all medical information, applicant's address, telephone number, case title, and case number. For those courts who store case information on electronic-based case management system, such as Odyssey, ADA documents are kept confidential and hidden from all public portal. It is only accessible by those authorized to view the documents. Judge Austin, where should hard copies of MC 410 forms and medical information be stored?
In our court, we send the hard copies to the main ADA coordinator, and they set up one central secured filing where all the confidential papers go during the accommodation process. Other courts place the ADA information in a sealed envelope within the case file itself. There are many different ways of handling it, and as long as the matters remain confidential and under seal throughout the process and even after that, as long as the case is being maintained by the court, that's sufficient.
Well, I have a real story regarding confidentiality.
Oh.
So an attorney at our court has a digestive problem, requested an ADA accommodation for 3 15-minute breaks in the morning sessions and 3 more 15-minute breaks in the afternoon session, plus requested an extended lunch break. So how it affected the court was he would be late for the afternoon session and claim that it was due to his digestive problem. So how did the court deal with the confidentiality of his request? We held a confidential hearing in a closed courtroom with only the attorney present to advise him the court will grant him breaks as needed because it does not have an adverse effect on the opposing party.
Oh, so the other party wasn't there during the course of the hearing?
No.
Or the other attorney, the opposing counsel?
That's correct, no.
That's because it didn't really involve the process of the case in any way or the materially affect the other side?
That's right.
Oh. I've got a story too. An attorney on behalf of a client files a judicial counsel form INT 300 for foreign language interpreters. That's a new form that was approved by the council just a few years ago, but it's foreign language interpreters, spoken language interpreters. The attorney requests an ASL interpreter in the other section on the form. There's a little box that you could check for that says other. The ADA coordinator, though, treated the form as an ADA request for an accommodation because Rule 1.100 allows requests to be made orally or on the MC410 form, which is the one that you're supposed to use for an accommodation request or when you're asking for an ASL interpreter, and this is in quotes, in another written format. So it's okay to write it out on a piece of paper, or you could, if you use the other form, that's okay. The important thing is it's an accommodation request, not just a standard request for an interpreter. Because of that, it has to be kept confidential, so it would go into the sealed file. So it's important to remember that when you're dealing with ASL interpreters. All right, disclosure. Let's talk about that. Disclosure is okay if, first, it's only to certain parties or persons that are those that are involved in the accommodation process. That language is specifically in the rule, as is the language, it's okay to disclose if required by law to disclose. Those are the two processes that are specifically set forth in the rule itself. It's important to know that confidentiality can be waived in writing by the applicant. So it's okay to disclose if it's waived in writing by the applicant. A lot of times, though, that's not how the applicants do it. They're in court and they want to waive. They don't write something down, but they'll say, I want to waive my confidentiality on this, because it's usually an easy type of accommodation to make, and they'll do it in open court. And if they do, then it can be taken down by the court reporter. That would, I think, constitutes a writing that would show that the waiver has taken place. Or a minute order would be okay as well, as long as the minute order reflects that there was a voluntary waiver by the person seeking the accommodation in court. And I think that would be fine too.
That's right, Judge. And one of the example I have is that a self-represented litigant sued his former employer for a wrongful termination.
Was another real story.
Yeah.
Okay.
And he has a cognitive disability and couldn't get things done and needed more time to accomplish his task. He submitted an ADA request with the court, but decided to talk about his ADA request in open court. So the judge in this case warned him repeatedly that if he volunteers his information in the open court, he would be waiving his right to confidentiality. However, the litigant declared in open court that no, he's not waiving his right to confidentiality of his ADA information, but continued to speak about why he needed his ADA accommodation. So a court reporter is at this hearing and transcribe what was said in the open court, then hence that was the documentation we needed that he waived his right to confidentiality.
That kind of thing happens with some regularity. I'm surprised. And it puts the judge in a difficult situation, because you want to maintain confidentiality, but at the same time, the person who doesn't, I think, often completely understand the process, wants to keep talking about it even though it should be done in a confidential manner. And there isn't a lot that you can do. As a judge, you could tell the person you have a right to have this be confidential, and we could stop the hearing, and this could be everything could be held confidentially under the rule. But if the person doesn't want to do that, there's not a lot that you can do to stop them.
That's right, Judge. However, I do have a different situation regarding disclosure. What happens when a party files a notice of unavailability and discloses in the notice his medical information relating to an upcoming surgery?
Well, that's just a disclosure by the party. The party disclosed the medical information and waived his confidentiality in the filing, because he filed it with the medical information in a public case file. That's another difficult situation, because they could have handled it a different way. They could have done it as an accommodation request and done it so that it would be confidential, but they didn't. When that happens that way, the court doesn't have to run around and try to figure out whether the person's waiving or not waiving if they voluntarily put something into the public case file that way. Although it's always good if something like that happens, that the judge explain, you have a right to have this be treated as an accommodation request. If you'd like to do that, it'd be confidential. And then if the person chooses not to, there's not much the judge is going to be able to do about it. Okay. I've got another real story. In mine, the litigant files a motion to set aside a judgment and attaches an ADA accommodation form and information having to do with lengthy ADA accommodation requests. But the motion itself, to set aside the judgment motion, it's in the public file and it's served on other people, other parties in the case. Anything filed in the public case file is not confidential. The litigant knew about the confidentiality of the ADA process because they'd been involved in it a lot, but for some reason chose to file this motion not as part of the ADA process, which you couldn't really do because it's a motion to set aside, but it chose to attach the ADA documents that were otherwise confidential along with the motion itself. Yeah, the thing that's interesting about that is the litigant could, there's a process for doing this, so if you wanted to use the ADA material that had been part of the confidential request, this gets a little deep here, but you could follow California Rule of Court 2.551, and that allows the motion to be filed conditionally under seal. It's kind of a complicated process, but the rule is pretty straightforward about how to go about doing that. So you could have it in connection with the motion, it could be served on the other side as a reason, possible reason for setting aside the judgment that was entered. You'd have a hearing on that. It's filed in a sealed envelope with stating that it's conditionally under seal. And then the judge later decides whether or not it should remain under seal or go into the public part of the file. If it remains under seal, no one will ever see the ADA-related material other than the other side who would have a chance to respond to the motion.
Yeah, I see.
All right, now let's talk about the Vesco case. That's Vesco versus Superior Court of Ventura County. Really interesting facts. Mr. Vesco and his girlfriend were in a long-term relationship when he purchased a house that they both then lived in. The relationship came to an end, and Mr. Vesco moved out of the house. His girlfriend stayed at the house without paying any rent. He ended up paying the whole mortgage. Mr. Vesco then decides, well, I'm not going to keep doing this. I'm going to end up having to bring suit, and which he did, to get the house back. His girlfriend then delayed the trial by filing more than one ADA accommodation request for a continuance of the trial because of conditions that she had, disabilities that she felt would not allow her to go forward with the trial itself. This was done in a way confidentially, just like we've been describing. It was confidential. The other side doesn't get to find out about it because it was an ADA request. It wasn't done as a standard motion to continue and have both sides noticed. It was done confidentially, and the court treated it confidentially, ruled on the accommodation request, granted the accommodation request, and continued the trial, all without any input or really knowledge about why from Mr. Vesco. He eventually figured it out somehow and decided that he didn't think that was fair and ended up going to the Court of Appeal. And the Court of Appeal ruled that Mr. Vesco had a right to have his trial as soon as circumstances permitted. Also ruled that Mr. Vesco was a person involved in the accommodation process. That's the words directly in the rule of court. And since he, in the confidentiality provision of the rule of court that we've been talking about, ruled that as opposing party, he was involved in the accommodation process because the accommodation process involved him. He didn't get to have his trial. when he wanted to have his trial, so it involved him. And so he was entitled to be a part of that process. The court said that he must be given notice of the request and an opportunity to view medical records and other materials in the ADA request, and to be part of a hearing before the court about whether or not that should take place.
That's interesting. So, Judge, what are the process involving Vesco?
Well, there's really 3 steps. It gets kind of complicated, really, it does, because you want to maintain the confidentiality of the process, at the same time giving the other person who's involved now in the process, because it's affecting them materially, a right to be heard. First is, does the continuous request meet the requirements of Rule 1.100? Somebody has to decide that before you go any farther.
Right.
And that would be, does the person have a disability? Is there supporting information involved? It doesn't repeat any kind of previous request. You have to get those out of the way first, whether or not, because sometimes people just want a continuance and they filed the form, but they don't have a disability, right, and they don't identify one. That's the first step. But if you go past that, and it does qualify under the rule, then you have to figure out the next step, and that's who notifies the opposing party about this process. And there's a couple of different ways to do that. Our court usually notifies first the person who's making the accommodation request. So accommodation request comes confidentially to the ADA coordinator. ADA coordinator, sometimes with the judge who's working on that case with the litigant, will look at it and decide this. We have to have a Vesco hearing here because they're seeking a continuance. We have a standard letter that's in the packet of materials that go along with this broadcast that goes back to the person making the accommodation request, informing them under Vesco, we need to disclose your request to the opposing party and get them involved in the process, and it could end up with some type of a hearing before a court about whether or not the continuance will be granted. Sometimes when you do that, people don't want to go forward with the continuance request because in doing that, you're now sharing their information regarding their disability and their accommodation request with the other side. And they don't want the other side to know about their disability. So sometimes they withdraw it, the request. Sometimes they don't, though. And when they do, then we set up a hearing a time to have a hearing and discuss it with both sides of the case. Other courts do it differently. As soon as they get word and they figure out this is a Vesco situation, they'll send out notice to the other side. And that happens routinely in most court locations. The third is what happens next. Right. The case of Vesco, they don't really talk too much about what's supposed to happen at the hearing or what rights the people have, but you clearly do have a right to see medical records and to explore and to if you're the opposing party, to raise issues regarding the validity of the claim, whether there's really is a disability or not. That comes up sometimes, the Vesco hearing. If whether the continuance is really needed as an accommodation, that will come up. And you have the hearing. The hearings are interesting because they're closed. Because again, the only people that can know about this are the people that are involved in the accommodation request. So now we've extended. It's not just the ADA coordinator, the judge, and the party who wants to be accommodated, but it's also the opposing party. So the courtroom remains closed, so nobody can come in. The documents all stay under seal, so nobody gets to see the documents outside of those litigants, and then you have a hearing. The hearing, everything stays sealed. If there's a court reporter and a record, that stays sealed. The minutes of the proceeding should stay sealed. That happens routinely, and it seems to work pretty well. There are some problems sometimes. A lot of times they want a continuance, and it's only like 2 days before the trial date, and there's a big rush to let the other side know about it and have a hearing. So
right.
That's difficult sometimes, but the process usually works out pretty well.
Right. Well, in my court, we actually had a Vesco hearing conducted in one of my cases where a litigant who was wearing a special medical boot wanted a continuance and even brought a doctor's note. and the doctor's note ordered that he limit his mobility, that he needs to stay off his boot or foot in this case. At the Vesco hearing, the opposing counsel said that the litigant had been seen walking in the courthouse the last week or so, filing new motions and responses, and even though he was wearing a boot. So the doctors know, although it indicated that he could not walk because of the boot, he was seen walking around with the boot. Therefore, his ADA accommodation request to continue the case was denied.
Oh. Yeah, that's a continuance story, and most of the Vesco hearings have to do with continuances. But it not necessarily the only kind of issue that can result in a Vesco hearing.
Really?
Well, the case itself is kind of vague about how you're supposed to go about these and what cases qualify for a Vesco hearing. It's any one where the opposing party is involved in the accommodation process, and clearly a continuance, that would be the case. Right. But maybe other items of litigation, you might be involved in the accommodation process if you're the opposing party. I've got a real story that has one, that the court, I think, rightly treated it as one that needed a Vesco hearing. There was a witness who had recall problems, memory problems, and wanted to use notes during her testimony up on the witness stand. And that would delay the trial, plus might be viewed as giving an unfair advantage to the litigant, especially if their attorney notes on how to act or what to do were in the notes. The court thought, okay, wait a second, they made an ADA accommodation request for it, but then thought this has some effect on the other party. And so I think they are now involved in the accommodation process and did a Vesco hearing. As a result of the Vesco hearing, the court allowed her to use the notes, but the opposing party was allowed to view the notes for any legal strategy information or little secret notes from the lawyer that might be in the notes that could help her up on the witness stand. The opposing party was allowed to view the notes only minutes before the witness testified. After the witness's testimony, the notes were taken from the witness and put under seal. So that was how that resulted, and it was all because of the Vesco hearing process. When they did the Vesco hearing, it was all under seal. So that part of the process wasn't disclosed in the public record at all. But I think the accommodation seemed like it came out pretty well.
Well, it all sounds very complicated.
Well, that's why this is the most important thing, I think, of the whole thing of our presentation today. You have to make sure, if you have any kind of Vesco issue, get your ADA coordinator involved, because you do a lot of these things. All of our ADA coordinators do, and they understand the process. They're going to keep the judges from doing anything they're not supposed to, and make sure that the rights of the parties that are there are protected. They're trained in this, and it's really important to make sure that they're part of the process whenever you're thinking as a judge that a Vesco hearing might be required.
Right. Well, Judge, I think we covered issues regarding the confidentiality provision of the California Rules of Court 1.100 Subdivision 4 and the Vesco process.
Thank you, Ms. Koo. And we hope that you found this program helpful. Thank you for joining us in this Continuing the Dialogue program.